I'm. We are getting it together.
All right, great. We are now starting a regular meeting of the Norwich Planning Commission. I believe, who is in the room on the commission? It's Jeff, Vince, Bob.
That's right.
Okay, and then we have Chris and Jan. Okay. So we have a quorum. We will get started. We have a lot on the agenda tonight, so let's plunge right in. Can I get a motion to approve the agenda?
Motion to approve the agenda while I thank Aaron and Vince, so I didn't have to call my kids to figure out this audio.
Yes, thank you. We will, and the select board should thank you since they're probably going to use the same stuff tomorrow night. And every step forward is good. All right, do I have a second on the agenda? Okay. Any comments, discussion on the agenda? All right. All those in favor of approving the agenda as stated? Great, thank you, unanimous. Correspondence, I think I just quickly to run through, you can look in the packet, anything that was particularly pithy, we have as agenda items. There's some general solar related letters that will go in the packet for the next solar siting subcommittee. Sidewalk letter feeds into multimodal committee, and then a note introducing the new regional energy coordinator. So I don't think we don't typically move to accept the correspondence, but that's what's in the packet. And with that, I would move to the preferred siting request for Aaron Lamperti on New Boston Road. Jeff?
Yeah, Aaron's a client, and I would like to recuse myself, even though the work we've done for Aaron is not related. But I just want to say that I need to recuse. So preference of the commission, I'm glad I'm going to go sit in the audience so that I'm not at the table.
Okay. All right. Thank you, Jeff. All right. So Aaron, we all have the packet information. I think it would be helpful to get a brief, very brief introduction. I think we better assume everybody read it. We try to do our homework. So is there anything in particular you want to highlight in the packet information?
No, I think the basic situation is that for several years now, I thought this would be a good spot for a community solar array. Various factors have, and I've done site visits with Green Mountain Power. I had Norwich Technologies up there. I had some excavators to look at the route, possible route for the power lines, buried power lines. And so the gist of it all is that to begin the process, really, I need to have preferred site status. I started talking a couple of planning directors ago about that process, and then things intervened, such as my being on the select board and stuff like that. So, but now I'm ready to try and move forward. If anybody has any questions about the packet, I'm happy to try to answer them. I could walk through it, but it seems unnecessary if you guys have all spent time with it. So I guess questions is probably the...
Yeah, so let's open it up to the commission for questions first. I had a couple, Aaron. One was just the what exactly does the word community in this context mean? Is that significant relative to a net metering use?
It means off-site net meter. So you net meter against accounts. Green Mountain Power electric accounts, and obviously the site wouldn't have meters, so you have to pick your meters somewhere else out in the community. So it's just in for off-site net metering. And I know, and maybe others know, that that's something that is now being discussed in the State Department and, or the legislature, and who knows what the future will bring with net metering or offsite net metering. But nevertheless, I don't want to wait 2 more years for them to see if they can figure out what they're doing. I want to try to move things along at a reasonable pace here. So I'm still looking for preferred site status. If offsite net metering goes away, maybe this project can't happen. I don't know, but you know, that the future brings that. We'll bring that answer.
Okay. So it's part of where the electricity goes and where the financing comes from, in a sense.
So you know, so we have the idea of a community solar project or an offsite net metering project is you form a collective of people who have power meters, and the net is a net against their power consumption. So
yeah,
you share the power production of the site. Either you divide it up in actual panels, and you know, an individual owns 5 panels or whatever, or it's just fractioned out on a power basis. But that's the idea. So you're netting against a set of meters, and those meters can change. It could all be one organization. It could be, you know, Dartmouth College or well, it has to be Greenwood Power, but you know, it doesn't have to be individuals. But often there are individuals maybe mixed with other organizations.
Yeah. So maybe to summarize, I think the topics that have mattered in the past have been view from neighbors, abutter feelings. And so my understanding from the packet, and if you can confirm this, is it true that the actual site where the array is will not be visible from any road, or just not from a designated scenic road?
I don't believe it will be visible from any road at all. I don't think it will be visible from anywhere in town, because just by the geography of the valleys. I mean, I suppose possibly we could catch a glimpse of it from the top of Guile Mountain, the tower of Guile Mountain, which would be above the trees, but I'm not even certain about that. I've tried to sort of see if I can see the top of my house. It'd be much lower than the top of my house, and I can't see my house, so I don't even think, Scott, you'd be able to see it from the watchtower.
And from any abutters property line?
Not from any butters.
Not from me.
Certainly not from Judy yet. We share.
Okay. And just for the commission's background, I spoke with Kyle about this. Kyle has done a site visit and confirmed, as much as he could tell from standing in a somewhat wooded area, but he could say that yes, it sort of appears to go up and then a little bit down to where the arrays are going to be. And so from the lay of the land, it looks like it will not be visible outside of a pretty local area.
Yeah, I'm quite certain that it won't be visible from anywhere but right around.
Okay. If there are no other questions from the commission, I would open it up to anybody in the public. Jay?
Yeah, I just had 2 or 3 questions, and they're more for the commission than they are about the particular plan, just from the learnings of the past. And I'm appreciative and have been reading the notes about your siting committee and other things like that. But where I've seen confusion in the past is, number one, in the town plan, what are the actual provisions for overriding the ridgeline protection area? Not talking about the individual merits of plan A versus plan B. It's sort of like if a tree falls in the woods, do you hear it? Does it matter if it's a ridgeline that you can see or a ridgeline that you can't see? And you know, in some ways, is the town plan our restriction on things like this? So that's just sort of quite, I'll ask the 3 together because they're sort of associated with it. You know, number 2, I think learnings from the last site that I was involved in was sort of the discrepancies between a presented idea and then an actual to be built plan. And sometimes those change a lot because you find different situations on the ground and other things like that. I think one of my big questions just is the amount of clearing. You know, if you do the math. This needs about an acre of an acre of solar site, but it depends on how much you need for the sun angles and things like that. So I'm curious as to the amount of clearing. And I think having the to be built plan as something that the Planning Commission, Select Board, and the regional planning look at is a good thing. And then just my third comment was when I read the letter about the process to get a preferred site letter, I wanted to clarify that how I've read it, and I'm not a legal person or expert, is that the Planning Commission, the Select Board, and the Regional Planning Commission, while they all may use the same data, they should be making an independent assessment. It's not necessarily that the Select Board is ratifying what the Planning Commission says. All three people are signatories of it. And I just wanted to point out that I think the letter said that the Planning Commission then creates a recommendation forward to the Select Board. I think we want people to be, or committees to be, thinking independently here. And that was just my third point. So that's what I had. Thank you.
Okay, just a second, Mary, I want to see whether, Mary, can you answer, or where do you stand on answering the how much would be cleared question?
How much would be cleared? So the site's partially cleared already because 30 years ago, I thought I was going to put my house there and then didn't. And then it also abuts my driveway and the my leach field. So a substantial amount of it is already clear. I don't have any sort of an as-built, of course, because preferred site status is sort of preliminary to starting to spend money on the site. So I can't give you a number. As you said, it's considerably less than an acre of panels. So, and then you have to clear some for the view, but like I said, the driveway and the leach field and some of it's already cleared. So, you know, it's certainly some trees will be cut, but and I've been cutting firewood there for a number of years anyway. So it really, and trees have been falling, so it's really not going to be a substantial amount of cutting. But yeah, there's going to be some trees.
Okay.
The other, do you want me to try to answer some of the other points, or they are more?
I want to open those up to the commission. I just was curious about the clearing, but let's go to Mary.
Yes, thanks, Jan. And just
Yeah.
to reinforce some of the comments that Jay made, some of them were similar. You know, we need some clarity around what the town plan and the zoning, because they're not fully aligned. And the town plan is really clear that there are three areas again, and this is where, again, just kind of advice to the new planning director. He noted there were two areas, the village and the ridge line. There are actually three in the town plan. It's the shoreline as well. So I just want to make sure that we have from the planning office correct instructions always, because we've not always had that. And so if we could have that clarified. You know, and I would say that given that 90% of the land in our town is automatically, does not need a preferred site, it's just astonishing to me that we keep coming back to the idea that we are going to create these solar panels in areas that are protected by our town. And I think a question around, you know, if that's what we want to do, if we've said we're protecting the ridge line, then when do we find a hall pass to let that go? I do want to double down on the idea of clear cutting. And so it's good to get that clarity, Aaron. I would say that last time this committee looked at a ridgeline kind of agreement, a preferred siting for a ridgeline, they were told it would take 3 acres of clear cut. It was a 3-acre site. We know now that by the time it went to the state, it was 8.2 acres. And there's some thought that it's perhaps more by the time you build the road that will get up there. And so I don't know really. I understand that Aaron wants to think about how to do this in a way that's financially reasonable, but I do think that we need clarity around how much needs to be clear cut in order to get enough sunshine in this very sunless state that we all live in to make this work. And so I would actually ask that additional work get done, because if it doesn't, then people like Jay and me who object to the clear cutting that happens with some of these sites end up having to spend a lot of time and a lot of money. And I think the job is for the town plan to really dictate that. And if people want to build in the 10% of the land in town that's not permitted to, that needs a special exception, that extra work needs to be done ahead of time. I would also like to point out that the town plan also talks about a principle number 2 being to guide development away from priority forest blocks. And on page 18 in the town plan, it identifies that forest block where this land is as the high priority forest block. And so I just want to think that, you know, we tend to go in very specific areas to try to make these things happen. But I'd like us to go back to the town plan and be very deliberate and intentional about looking at all the things the town plan is saying about what we want our town to be, and then to make decisions. Because again, there's 90% of the land in town that if you want to do this right now, you can just go do it. So thank you.
Okay, thank you, Mary. Comments from the commission first? Okay, just to address a couple things. I believe that from the Ridgeline Protection District point of view, clearly the way the bylaws are written, it is designed to be a protection of the aesthetics and the scenic and the view and all of the process where the DRB reviews it against those criteria are to mitigate, screen, it is not to preclude development, it is to make it so that it, put some trees here, leave these trees, put the buildings back off the top of the ridge. Those are the sorts of things that happen based on the bylaws. And so I think that's appropriate. The Ridgeline District is not a prohibited district. It is one that gets special attention. This is my interpretation, and others certainly can chime in. And so I think that's what we're talking about here. That's why we're asking about views, and then same thing on the forest blocks. I do agree that same question. If we were clearing 20 acres, if we were doing it in a place that was really identified as, a bear corridor, you'd have to really look at that closely. So all of these things are the kinds of things we should be talking about and are. I think this site is different. It appears to me from the mapping and the visits, that the topography is considerably more hidden, and the neighbors, steep slopes and so forth is very different than the previous case that I think we're coming from. One last thing I would put out there to the commission, because I think it was important, would have been helpful in the previous case, around what's presented initially and what it develops into. And I would ask, or I would like the commission to consider some kind of a provision where we say, if we said, yes, we agree to a preferred siting letter, that is contingent on the applicant returning to us when there are more detailed plans, and we have the opportunity, if there are substantial changes to what was presented initially, that we can revisit the preferred siting letter. So I would put that out as some kind of a proposal to the commission, if that was something that people were open to. And Jeff, I would just say that it's up to you, but I would feel comfortable with you commenting on process and general comments around the siting and so forth, not this specific application or something.
Yeah, after this is heard, Jan, I can't say a word relative to what you're talking about.
Okay, that's fine. Jack?
Thank you. Just need to unmute.
We can hear, I heard that.
If you just bear with me a moment.
No problem.
my wife is in the same room on her account and needed to mute, so we didn't get a feedback. Thank you. And thanks for the consideration today of this proposal. I have one question and then one brief comment. I think I heard earlier the preferred siting letters are not sent from the Planning Commission to the Select Board for them to rubber stamp, but rather that there are 3 participants in preferred siting, one being the Regional Commission, one being the Select Board, one being the Planning Commission. If that's the case, then I can't really see how Jan's suggestion that the Planning Commission put a proviso on its preferred siting letter, if there were to be one. How is that consistent? Would the Select Board have to have the same proviso, and would the Regional Planning Commission have to have the same proviso? Or does this just introduce confusion? We, I think, all understand that a preferred siting letter is the first step in development of a plan, because the costs to the investors are prohibitive when there's no preferred siting letter. And that only after obtaining a preferred siting letter, which basically allows a solar site to begin its lifetime of process, would any of these materials be developed. And then secondly, I would just like to take the moment to make the comment that I and many other people in town hope that the Planning Commission is attempting to maximize our appropriate use of solar energy in this town, because we all understand that it is not possible to avoid the worst risks of climate change without a radical, dramatic shift to solar power everywhere, and that Norwich, under state law, has its part to play in behaving responsibly in this way. Thank you very much for your time.
All right, thank you, Jack. I think just to, I see Linda, just to answer Jack's, my understanding on the preferred siting letter, and I'd have to go and look back on the official things, but there are 3 independent signatories to a preferred siting letter, and the PC, the Regional Commission, and the Select Board. And the preferred siting letter needs all 3. So I don't think it's necessarily that all 3 need the same proviso, because any one of the 3 not being a signatory makes it not an active preferred site. That's my understanding, but I would have to confirm that. Linda?
Hi, thank you. I just want to say, with regard to like this process questions, that I'm a layperson, but my understanding is that it's through the PUC Section 248 process that the town would be a party and would monitor the specifics of a project proposal. Like at this point, Aaron is applying and he doesn't have a project proposal. He doesn't have a developer he's chosen to work with. He's saying, here's a site that in the future I would like to offer for some solar development. And it's up to the town to say, yes, we're okay with this. And that's necessary if the development turns out to be a net meter project. And other details about the project will come out through a detailed application that's submitted and operated on through the PUC process. And that's where the town gets to weigh in on other aspects of things. So I'd just like to highlight 2 different processes. One is town level, the rest of it is state level, and the town gets to participate in that. And then separately, you know, from participation at the solar siting subcommittee level, that there is, in fact, something, and nobody is trying to enforce it, but each town has a responsibility to try to support X amount of megawatts of renewable energy generation. So if we're to take that seriously, we've got to do stuff like this. And I think this seems like a very good site. And I certainly urge the Planning Commission to support it.
Great. Thank you, Linda. Jay?
Yeah, I just wanted to clarify, Linda, I'm not sure if I completely agree with what you just said from the perspective that just it goes to the PUC and then the town participates in the PUC process, because at least at the sites that I've followed, the town hasn't participated once it goes to the PUC. Now, can it? I'm not sure, but I think it goes back a little bit to Mary's point, is that the reason this conversation is happening is that only 10% of the town's land is by the town plan not available to be a solar site without the preferred site letter. So most sites can go right to the PUC process without this, I'll say, pre-process or bureaucracy into the process that we have to go through. So it's also supposed to be a gating for the town, of the town trying to figure out what its town plan stands for, you know, and I'm a process guy, so my feeling on this is it's ambiguous to me a little bit on how to deal with the 3 different protection zones, and wanting to do something that's outside of those protection zones. And Jan, I really appreciated how you framed it as that they're not prohibited, but that it's for us to have consideration. And this is part of the reason why the AT started to buy the corridor, and then they started to buy the view sheds, because you don't know what's going to happen to this various corridors. So personally, I'm a big proponent of solar. I have it at home. I think doing solar in the right place makes a lot of sense. I just want us as a town to be clear on how we do this and how we do it right, with the transparency that we want to have as we go. My dog agrees. As we go through all that. So thank you.
All right. Thank you, Jay. And maybe to clarify, and I think this is the accurate way to put it, in terms of the participation, 2 levels of participation, the preferred siting designation is the first, and then the town, either the Planning Commission or the Select Board, can ask for and be granted party status to the PUC proceedings. And that is then what gives you, and this is for people who've been keeping up with the solar siting subcommittee, this is the advantage of having a enhanced energy plan, which we are working towards. You then, in that process, have more influence. You then are given substantial deference as opposed to due consideration. And so the point is that there are really two ways for the PC to be involved. For the second one, at the PUC level, we need to ask for party status. And so that's my understanding, and we can obviously clarify. Jack?
Thank you again. First of all, I neglected to mention when I spoke earlier that I live a few hundred feet from New Boston Road in this vicinity, and am more familiar with the lay of the land than in other parts of town. Secondly, my understanding is that if anybody in this town wanted to build what might become a net metering array of this size on their property, that the denial of a preferred siting letter at this very tentative stage would effectively kill the project. Is that understanding, generally speaking, correct?
Yeah. I mean, we can ask Aaron. It is important, and I don't know, you don't get as much for the electricity. There's certainly a financial aspect to it. And depending on how tight your budget is, it could certainly make or break a project. That's my understanding.
Perhaps I wasn't clear, but in a net metering possibility, which this clearly is, nobody would start a process of investing in what would become a net metering project without a preferred siting letter, because that's a prerequisite for, am I mistaken about this? I'm asking the question.
I think I mean, I'm not
Jay,
a lawyer,
just
Jack.
wait, Jay. I
Sorry.
mean, my understanding is that it is an important gate, and it would be exceptional not to. But Aaron, what do you think? And then Mary.
I don't have any special knowledge about this, but there's definitely a better rate if you have the preferred site letter, and that it's prohibitive in a financial sense. You wouldn't proceed with a project unless you're just deep pocketing it, if you didn't have that better rate. Otherwise, it's not that.
Yeah, that was my understanding. Mary?
So thank you. I think, again, getting back to process, you know, I think this idea of provisional site was discussed last time with Rod in the site over near where, on the steep slopes. And Rod said, no, you can't do that. So you'd have to decide whether or not you can do a provisional thing. In terms of killing the project, Jack, I don't think it kills, if there's a denial tonight, if it says, you know, we're not ready to do it yet because we need more information. We need to know how big is this clear cut, because that's going to be important. I think if it's ultimately denied, then yes, I understand it, that stops projects. You can't go forward to the PUC without a preferred site for this. But, you know, you'd have to talk to your lawyers to get that confirmed. But I also want to comment on the idea that the town would get involved in monitor projects, which we would welcome. It would be great if the town continued to do that. I do want to point out that the town did get involved in one of the sites, and when the lawyers for the corporation that's constructing it started threatening lawsuits, I think that was a kind of a moment. So let's all be clear that someone's got to take initial steps to invest in figuring out whether this project really does abide by the town plan. And I would argue that it's not the town's responsibility to do that, that it's the person who wants to develop it, to do enough work to know that this is going to, follow the town plan, and then present that information, and then the town can support it, rather than having the town say, well, we think it's going to be okay, so we'll give you permission, and if not, we'll have to come chase you. The PUC is a very complicated beast. You need lawyers, you need expert testimony, you need years. It's not easy. So the process is that we do our homework now to know that this abides by the town plan. And at this point, I would say, we don't know how big the clear cut's going to be. We don't know if there are vernal pools. Maybe there are, maybe there aren't. We don't know. You mentioned, Jan, is there a Bear Carter? I don't know if there's a Bear Carter. It's a big forest product. So we need to find out, does this abide by our town plan or not? And then make the decision, not put the cart before the horse.
Thank you, Mary. Jay, and then I want to wrap back around to the commission. And Aaron, I see you. Jay?
2 points. I want to go back to Jack's question, because I think that's an excellent question. And I thought, and I'm not a lawyer, but I'd be really interested in other people's thoughts. I thought the whole reason this conversation is happening tonight is that this particular site is within a restricted area, but that how our town plan reads is anything that is not in a restricted area is already a preferred site. And therefore a preferred site letter is not needed to go to a PUC. Now, I might be wrong there, but that was my naive interpretation. And I think your question is a great one for us to understand, meaning if someone wanted to go do, I'll pick another controversial piece of land, a solar site in the field across from Fogg's Hardware, and it's not in the Ridgeline Protection Zone or the downtown area or the waterfront, that is not in need of a preferred site letter. Not that I'm suggesting that, but I'm just trying to be black and white there. But I'd love to be educated that my interpretation is wrong there. But I thought your question was great, Jeff.
All right. Thank you. I mean, I know that there are limits on the town involvement in these sites. The state has pulled back, normal zoning bylaws don't apply except for the preferred siting piece and the participation of the town as a party in the process. So obviously you'd have prime eggs and you'd have vernal pools and there would be A&R and it would be other elements in the process. But the town's particular influence and hooks are made pretty narrow. I need to wrap this back to commission and see where we want to take this tonight. I think my question to the group would be, do you know enough to do something tonight, or is there a list of things that you want to know more before you make a decision? I think, Aaron, you had your hand up before.
Well, a lot's been said. I just want to remind, I know that the commission knows this already, but the preferred site letter or status is not permanent. This is not a question of deciding whether or not this project is allowed to proceed or not, and all of the things that are being mentioned, wildlife corridors and all of that, is not actually irrelevant to the question of whether or not this site is preferred for solar under the enhanced energy plan of the state of Vermont. That question is based on the town plan, and as you've already discussed, the issue here is whether or not this site is going to be visible from certain roads, basically. And it's not going to be visible from any roads, let alone certain roads. And New Boston Road, which is the only one you might argue conceivably could somehow be visible from, isn't even one of the ones that's irrelevant. So strictly from the text, as I understand it, of the town plan and how preferred siting works, none of this stuff we're discussing is really actually relevant to the decision you're making tonight. The question of whether or not the site across from Fogs, if I were trying to develop that site for solar, there's no way I'd go to the PUC without having a preferred site letter. Of course I'd have a preferred site letter. It's just generated automatically by the planning commission, by the zoning administrator, based on the town plan, without having to go through a signing process with the three parties. So the only thing that's happening that's different here tonight is that I'm saying this site is slightly abutting the very broadly painted across the map ridgeline protection area, which is the ridgeline wanders all over the place, and this line is fat and straight, and so it's really very largely a formality. And I understand that people are upset about other sites for other reasons, but this site really doesn't touch on any of those. And I would think it would be really an abuse of the process to cause a big delay on this simple first step that is not going to cause any trees to be cut down or anything else to happen. It's only going to allow me to investigate the possibility of this project, which I think is a community good. And I think if you asked other people around town, if there's a site that was off in the woods that couldn't be seen, that was partially cleared, that didn't have vernal pools or any special wildlife habitat, had scrappy, crummy trees, was going to be turned into a solar site, they would all say, well, sure, why not? And there's no trails and anything. So I think this is getting a little overboard.
Yeah.
Sorry if I'm overstepping.
No, thank you, Aaron. No, Judy?
Is this a time for me to speak? I'm in a butter.
Nope. Yep, go ahead.
I've lived 50-some years on the land that abuts Aaron's land to the south, and I own the property on both sides of the driveway that he uses and will be used for this project. I'm very much in favor of it. I've spent a lot of time over the last 50-some years walking around up there. I can confirm there aren't vernal pools there. And the land between my house and the property line for Aaron is really steep, and then it levels off, and then it's steep again, and then it levels off. So I think even if somebody were to cut all the trees down, you still wouldn't be able to see the solar panels from any road. You'd have to be way high up to see them. So I am very much in favor of the project. I think it's looks to me like an ideal situation for it. And it seems to me that all the other things that have to be approved and passed are things that Aaron will find out as he's doing his research after he gets the letter that he needs. So
Okay.
I don't see that he has been lax on doing his homework at all. It just hasn't been time for all that homework yet.
Mm-hmm. Okay, thank you, Judy. All right, I'd like to come back to the commission. Vince?
I just wanted to speak to your contingency idea of having an option down the road if things turn out to be substantially worse than we think we would as far as clearing or wildlife or anything else like that. Is that tied to your discussion with the PUC about the town having a party status, or would there be another mechanism in place specifically for the planning commission?
It is definitely tied to the participation in the process. That's a given, and I think the select board has said they want to be party status on solar projects going forward. I think that's perfectly possible that the planning commission would do that, and that would give visibility and some influence at that stage. Whether or not there is anything that's done hooked to the preferred siting letter, I'm not sure what's possible, but that would be separate and independent from party status influence.
Can you clarify, did you say the select board would have party status and
The select board in previous meetings has made their policy clear that for essentially all solar projects in Norwich, they will apply for party status. They'll hold public hearings in such a way that they are granted party status. It's a policy statement they made, I believe. Chris?
It's in the town plan that the town anticipated being participants in the 248, all 248 reviews. So this has nothing to do with our group or any other group. It's in the town plan. I don't know what page it's on, but it's written down that the town will participate in 248 reviews.
So I think if that's the case, then I don't believe it happened in the Upper Lovelands, because we didn't have party status in an official way in that, to my understanding. But so I think we would be conscious, we would want to make a conscious statement that we wanted to do that. We could do that as part of, you know, this planning commission, and to put my feelings on the table, I think this is, you know, as Aaron and Judy just said, this is a site with minimum impacts. The point to a ridgeline district is to make you take a second look at sites so that you are careful and don't miss something. We've done that, and I really believe this is this at this stage appears to be a good site. I would also say, and we should sign up and commit to getting party status for the planning commission going forward, and that would just be the best way to have influence. But I'd like to hear from Bob. Do you have any feelings on one way or the other?
It sounds as though our charge is to, I mean, if this is not automatic preferred site, to assess the scenic ridgeline protection. There was a pathway laid out by Kyle, and I think we all have confidence in his in the steps that he laid out. It's in the packet, and if it is, I mean, if by the town plan our focus is on scenic ridgeline protection and it can't be seen, it seems pretty straightforward to me that at this step we are makes sense to move forward with granting preferred status.
Okay. Does somebody want to make a motion? If we get a motion that includes both preferred siting status with the commitment of the planning commission to obtain party status going forward in this project's process, that that has sort of a hook at the end. Can I get a motion?
Yes, I make a motion to grant parties preferred siting status to the item in question, and we would, not sure how to phrase this, attempt to engage in party status with the process, 248 process.
Yeah, PUC 248. Okay. Do I have a second?
Second.
All right. Do we have discussion on that motion? Okay, I'll call the question. Bob, how do you vote?
Yes.
Vince?
Yes.
Chris?
Yes.
And I'm a yes. So that's unanimous of those in the case. Thank you, everybody, for your input. And I think we will continue with the process of the enhanced energy plan, which, as I said, links to that party status piece and gives us more influence in the process. So that's part of the advantage. But we actually will talk about that later in the on the agenda. All right. So thank you, Aaron. It's the first hurdle, and we'll look forward to hearing as you go forward.
Good. Thank you, everyone.
You bet. All right. Thank you, everyone. Let us move on. Any passing comments, Jeff, now that we've passed that on? Do you have any comments on the process?
So if I have comments to offer you on, it should be on a future agenda.
Okay, that's fine. We'll have plenty of opportunity to go over the process. All right, the next item on the agenda is chair notes. I've got a selection of news and updates for us, and I'll try to get through it quickly. The farmers market project, which we discussed at a previous meeting, has been slowed or paused right now, at least certainly from our point of view. We don't have to do anything about it. They are having a little more complexity with landowners and sale. And so we are not the long pole in the tent by any stretch. And so we can pause. I think the point that I would like to make, though, is if we should still leave it on the list of our, the list of, if you're going to touch the bylaws, here are some things to consider. The idea of a farmer's market being a permitted or a conditional use in rural residential should still have a little placeholder on the list. Because if it was a decent idea when the farmer's market suggested it, it doesn't mean it's a terrible idea just because they went away. So I think we leave it on the list, but in terms of urgency, it's dropped down several notches. Jeff?
Yeah, so how do I say this? As far as the state's growth policies, the regional planning commission's growth policies, our regional planning commissions in this region, their growth policies, all suggest whether utilities, travel corridors, yada, yada, that's where we should be thinking about housing. So perhaps we could consider as a town, if we have a housing need, what our best sites might be with respect to the foregoing. And then think about, and I'm not foreclosing the notion of a farmer's market in any context, think about how we overlay the farmer's market in that context.
Yep. Okay.
John, can you guys, I'm having this real sounds really garbled. Is there?
I do, or the other room?
The town hall. Are you guys still on some sort of weird speaker thing, or?
It shouldn't be any different.
That may change, right?
Vince sounds very clear.
We can move a microphone closer to Jeff, but the microphone shouldn't be any different.
Oh, Vince comes in
Okay.
very clearly, but I can barely understand Jeff.
I'm getting agreement from Amy that they sound garbled, so we'll have to ask Jeff to take the marbles out of his mouth. All right, and just speak clearly if you can, and please, anybody who didn't hear something, ask for it to be repeated. So that's the farmer's market, and Jeff, your point well taken, and obviously those things need to be on the table when we're talking about changing of bylaws and so forth. Next topic is on the maps and using NIMRAC as our host. And that's actually going very well. That's good news. So I spoke with them, with Adam at NIMRAC. They host, just to get the dollars in people's minds, it costs $750 a year for the listers to have that interactive parcel map hosted on the web. And they already had, as I said, they had GIS compatible overlays for our zoning districts, the Aquifer Protection District. I have since found, and actually Marcia found them, they were on the Vermont Geodata, if you knew where to look, made by Two Rivers Ottaquechee, Ridgeline, Scenic, Aquifer Protection. I haven't done a direct comparison of all the zoning maps, but clearly 6 or 7 of them we already have. There may be 3 or 4 that we need Pete Fellows at Two Rivers to make an overlay for us. But if we want to use the same map, and I think there's a real benefit to having it stay one map, because then if I'm an applicant or I'm a DRB member, I can click on that one map, I can see the parcel boundaries, I turn the overlay on for Ridgeline, like Aaron would say, am I in the Ridgeline district? Yes. So I think there's a benefit, and it saves us $750 a year. They could do us a separate map that still had the parcel information, but was the zoning and planning version, that had its own web address and so forth. But to me, that's just bifurcates makes it a little harder to find. But we would need to work with the listers so that if the lister says, no, we don't want to clutter up our map with overlays, we'd have to have that conversation. But worst case, it's another $750. It's $95 an hour to get Adam at NIMRAC to port in those GIS overlays and get them to be selectable on that portal, which is pretty quick with the GIS stuff. So I would propose that that this is a very good way to go. We can get an exact list of the overlays we need and that we have and that we need. Get Two Rivers to give us a quote for filling in the gaps and getting us the ones which I think are going to be 2 or 3, a few $100 kind of thing. And then the $95 an hour to put it in to that thing, and boom, we would have a web accessible, interactive, with all the overlays in place. Jeff?
Yeah, so what I'm hearing you say, Jan, is we're going to basically utilize what the listers are doing currently and engage Two Rivers to provide overlays for this firm to integrate as an overlay with what we're doing for the listers. In a nutshell, I think that's great. Given the Vermont Center Geographic Information baseline, Two Rivers involvement, that seems like a really straightforward way to keep things moving.
Yep. Yeah, I was excited to hear that could work that way. Any other comments? At this point, I would propose to go forward with that, and barring any complications from the listers, do people agree with the idea of keeping it unified as one map, if we can do that?
That's great.
Yeah, that's good.
Yeah,
Okay.
Jan, our interactive map today is pretty good.
Yeah. Yeah.
I've BCGI, just sync it. As long as we all know the boundaries on these plans suck.
Yeah, well, we learned that something on the Sharon Town line, which I can jump to that if we're done with this topic. But because I was talking to NIMRAC and there had been a conversation, actually Kyle had said, oh, maybe the person who does your boundary lines could help with this abutters concern about double taxation of being in Sharon and Norwich at the same time or whatever. Adam pulled up the survey that was on that property, and well, first he said, yes, there are boundary line issues all across the state, and the state has really no plan to fix them. And so then he said, well, it looks like this survey, when it was scanned in, was rotated a few, 15 degrees wrong, so the lines didn't line. But then he essentially abdicated and said, I don't know yet. And since then, Cheryl said there are like 15 properties all along the line there, and surveys are the gospel truth, and you have to dig in. Jeff?
Yeah, so if there's any individual in public office in this town that thinks publicly available boundary information is worth a cow patty, that person should resign from his or her position in public office. So I think what we should do is acknowledge it's all meaningless boundary wise. And I can give you anecdote after anecdote. But as a planning commission, as we think about what the DRB is up to, so to the extent applicants submit plans for approval, part of the approval process should include, here's the digital version of the boundary and how it relates to Vermont state plane coordinates so that it can be interfaced with our base map, which then can be interfaced with the state base map. Yep.
And that was essentially what I got from Adam was, and Kyle, I think, were both, it's the surveys, you gotta deal with the surveys to get any real information. You can't wing it off of anything else. So they don't, that was agreed. So that jumps around. On the New Boston Road affordable housing project or planning grant, they did a chunk of work. It's in the latest draft is in the packet. The significant difference was based on concerns about staffing and whether or not Two Rivers doing grant applications still required the town manager's office to do too much. They have, as you see, proposals in there to have a third party do both grant administration and project management. And they did some kind of an RFP relative to, they interviewed Habitat and this other group. And we're talking $6,000 worth total. That will be discussed. It's on the agenda for tomorrow's select board meeting. And then they'll work on getting the public hearing at the right time for 15-day notice and still making the application deadline. So I think that's moving forward, 2 steps forward, 1 step back kind of thing, but it's moving. Okay. On the hiring, unfortunately, we made an offer to the candidate. The candidate declined the offer. So we are back to having an open position for the planning director, zoning administrator position. And so that's where we got to. It's unfortunate. I was disappointed. We need to decide, for example, whether the DRB had decided not to replace Jack Candon in the conversation just because we were pretty far along in the process. We'll need to decide, ask them again, how they want to be involved. But that's where it stands right now. I haven't talked to Kyle, or I haven't heard Kyle's response in terms of availability into the future. So that's where that stands. And I think we did Sharon boundary line. Okay. So then for those planning and zoning nerds that get into things like lot consolidation and mergers and so forth, we will open that one up. Yes,
Sorry, sorry.
no problem.
Kind of processing that little bit of information.
Sure, go ahead.
I guess my question would be that you guys had, or somehow the town has now decided to put the title planning director out there. And somebody didn't take the offer. Now that might be the individual. Or can we actually get into the discussion of this or not? I'm not quite sure.
Not candidates, no. Or
Not the
candidates.
candidates, but whether or not there was an issue of whether it was I'm at a loss. I don't know how you get
Yeah.
into the discussion.
Yeah, it was not a job description issue. It was a personal life status decision. Jeff? Yes, Jeff.
We put this on the agenda for our next session because I might agree with Chris, but it's not on our agenda tonight.
Okay.
So-
All
Fair
right.
enough.
That's, yeah, and I would like to have conversations around it because we could talk about ZA. We could open it up to different conversations given this new information, but it was just an update on my chair report, so we'll put it on for the next meeting.
Thanks, Jan. If we can next time, I'd like to open up the whole notion of the position, the description, et cetera, as Chris has alluded to.
Yeah, understood. And I think that's valid. And just for the sake of information, I went and looked. Thetford has what appears to be a part-time zoning administrator. And so I was going to dig in a little bit and see how that was working for them. But anyway, we'll put it on an agenda coming up. So on the lot consolidation, and this one's a little bit pithy, but it's not necessarily, well, it's ours to deal with if there are changes to the bylaws required. Now, and maybe Jeff, you can give the background easier than I can, but let me give the 2-sentence version and then I'll ask you to help with it, because you saw in the packet as essentially both Rod Francis and Kyle a week ago gave the same opinion, which was our bylaws, when read by those people, definitions mean that merging two lots, so the outside boundaries of those two lots didn't change, but the inside boundary evaporated and you got one lot instead of two, that consolidation or merger required a permit. And that was their opinion. Then you can see in the packet from a letter that's Jack Candon and others, and then one recently from Margaret Jacobs, strenuously denying that that's the case and doesn't have, the state, nowhere else did they do that. So that's my reading, and I don't have an answer, but that's where it stands right now. Jeff, do you have any other wisdom on that?
I'd like to put this on an agenda item in the future to talk about as well. I'm not sure how to say this. I don't agree with Rod or Kyle, and with all respect to Kyle, I completely agree with Margaret and Jack relative to the state law. So the issue is, if we're going to change our subdivision regulations, if we think it will provide clarity, let's just put that on an agenda item talk about it, but let's understand that when we say we're gonna make that change, we're gonna suggest to the select board that they make the change after we have a public hearing, or 2 or 3 or 10, whatever is required by law. And I'm being
Right.
a little facetious at this point. And then the select board does the same thing for that little bylaw change.
Yeah.
And I would like to note, I think that the town's attorney, with whom I have not previously agreed on anything, seems to agree with Margaret and Jack.
So we're on an agenda item, so I think we can dig a little bit in here. We've got it on today's agenda. So I guess my question to the group would then be, regardless of what, whether Kyle's read is that we would need to change the bylaws to make this clear, and it would be essentially an administrative, the ZA or could simply say, yep, I accept that consolidation, and that was the extent of what's required for such a thing. So I think it would be worth getting the group, since we got an agenda item, is that the agreement of the group, and then we can go about talking about implementation details. But are we in agreement that, especially if state law seems to, be on the side of make this simple, that we would like to clean up our act and make it simple? Jeff?
Yeah, Jan, we're talking 2 different things, in my opinion. If we're looking at a boundary line adjustment, that is not the same as taking 2 lots and merging them.
Correct.
Those are vastly different premises. So with respect to the Vermont Agency of Natural Resources, there is a threshold about boundary line adjustments that addresses wastewater capacity that I think should be adhered to and may require DRB approval, which is not the same as taking 2 lots and merging them. So I want to be very clear that.
Yep. No, it's a very good point. My understanding of this conversation and the title of the agenda item is lot consolidation. It is merger of 2 lots into 1. And is it the sense of this group that that it makes sense that that should be a straightforward thing to do, that could be done at the discretion of our zoning administrator? And if that's the case, then we can hopefully have somebody, volunteer to dig into it a little bit and come back with specific implementation ideas. Jeff?
Yeah, so yes, so long as one of the lots is developed, the other lot is not. So to the extent we have an undeveloped lot or 2 undeveloped lots that we're going to merge, I have no issue. If we have an undeveloped lot and a developed lot, I have no issue. If we have 2 developed lots, now we're back in the Agency of Natural Resources realm again.
Wait a minute, can I just ask you a question? Not that this probably doesn't come up, but why would 2 developed lots want to merge in the first place? I mean, I think what they were talking about is,
Yeah. Well,
I don't think it would ever include, from a lister standpoint, it's never included something like that. It always includes 2 I think what Cheryl and the listers have dealt with is 2 undeveloped sites that they're merging, or 1 half developed, and what, from a property valuation,
yeah. So let me clarify, because I think it's kind of ours to choose what we want to focus on. But I do think that what's been put in front of us is merging or consolidating 2 lots, only maximum one of which is developed. That's the bound. Whether if somebody wants to come to us and say, oh, we should simplify putting 2 developed lots together, that's a separate question. That's not the one we're talking about. We're talking about consolidating lots, 2 lots of which no more than 1 is developed. So, and that's the, Margaret Jacobs's client is trying to do that. And the reason you do that is because it lowers your taxes if you have no intention of developing the other lot.
Exactly.
it's a relatively desirable thing to be able to do.
Yeah, PPNR is very clear about that. The town of Norwich is one of very few towns in this state that actually assesses you on your subdivision. And our assessor said that to us. That you guys are kind of like our preferred siting. We just happen to have these anomalies in this town. So
I prefer to think we're special, but yeah.
special, well, yes. But yeah, no, it's very
Okay.
clear that most towns do not want to, and people in this town wouldn't have to jump through these hoops if it hadn't been done this way. Now, Cheryl wouldn't agree with that because she likes texting us on everything, but joking.
So can we,
I agree to do that.
okay. So with that focus, can I get a sense, and we can do a motion, or we can just get a sense of the group and then feed it into a kind of an implementation specific task going forward. So let's get first the sense of the group that we agree with the idea. And just that slice, it's not changing boundary line adjustment, permitting requirements. It's not 2 developed lots. It is merging or consolidating 2 lots, only one of which maximum or none is developed. Does everybody agree with that idea? Yes, Bob, Vince, okay. So that's unanimous, doesn't have to be a motion. Can I go so far as to ask for a volunteer to dig into the implementation a little bit? Because I hear Kyle quoting something in our bylaws. I hear, Rod's going back. I would like someone to just say, this is what you need to change to make this happen. Jeff?
Yeah, I'm glad to do that, Jan, so long as you're with me.
Okay, I agree.
Physically or emotionally?
Emotionally.
Yeah. No,
Okay, that's great.
There's one of 3 gifted autistic people sitting at this table. No, that'd be great. I just want to have a little bit of cover going forward.
Yep. And the only thing, and I do not want to open up a can of worms here, but the question will always come up if you're going to change the bylaws and go through the public hearings and go through the select board public hearings. Are you going to do it for one, or are you going to look for a couple other real easy, low-hanging fruit, everybody would agree on this kind of changes? And you put very many things in that cart and it doesn't go anywhere. But I just, right now, we won't even touch that. What we're going to come back with is how to implement this change.
Yeah, Jan, so if my agreement to assist in this paradigm does not agree with the select board's rejection of everything they put forward going forward.
Yep. Okay. Got it. All right. Thank you. That was relatively painless. And could be helpful. I really want to get some successes where we can point at and say, look, we made things a little better here. We got some agreement. I'm just dying for it. So let's see what we can do. And if we can get people's eyes to glaze over on lot consolidation and it works, and a few people know that it helped, great. Okay, subcommittees. And before we go into specific subcommittee reports, and just for people to keep in mind on the time, we have 3 sets of minutes to approve, a couple of which I know have some edits. I don't want to keep building up too many minutes that we haven't approved. So we're going to need a little bit of time at the tail end to approve minutes. So let's just keep that in mind. The subcommittee, on the first line item there, which is more general and process rather than content. And it's driven partly by by Marcia's endeavor to have a handbook that describes who are the groups in town, what's their charter, who are their members, and from the point of view of, I kind of pictured in my head the the Women's Club Norwich phone book resource that's put together and collected, and when you want to call somebody in town, it's easy to find them. You know, that part of the purpose, I totally support. Visibility into what groups are doing what in town, and who do I call to ask about a transfer station question, you know, so that part I support. If it flips, and there were certainly comments at the select board meeting, which I took exception to and said so, where it was gets to a control issue and who gets to appoint members to subcommittees, then I'd like us to really talk about what we're agree with and so forth. But I think it's perfectly legitimate to say we have a multimodal subcommittee, and here's their charter, and here are the members, and we have a solar siting, and here's our charter, and here are the members. I would very strongly say that the Planning Commission makes its own subcommittees and sets their membership. And with that, I'd open it up. Jeff, if you were convincing to me about why the benefits of having 5 members or more on a subcommittee was a good argument. So if you want to try that again.
Yeah, I can ramble, as you all know, so I try to stick to my glib self tonight. The issue with Vince and I on this multimodal subcommittee discussion is how do you send an email to one another without having to notify the public? And so my personal opinion is the subcommittee needs to be constituted by at least 5 members. And benefit of that is 2 people can say, hey, when are we gonna have the next meeting, without notifying the public to ask when we're gonna have our next meeting. So that's my basic premise. I have a lot more to rant about this, but I've just answered your question, so let me know when I can rant more.
I think what I wanted, well, maybe can we separate out the two? Because again, I'm looking for agreement, and then we can hustle over the other parts. Do people agree with the premise that sort of visibility and transparency into who are our committees and what they're, and that they should have charters, for example, is that, do we agree on that, and then we can build off of that, or what do people feel?
Go ahead.
Vince?
Say that I think it's fine. It sounds like if it's printed in a handbook, it's basically a consolidation of the website. Like I like what you've done on the planning, or whoever's done it on the planning commission website, where you just go to the subcommittee. It's got the information on the subcommittee in their minutes. It's basically a physical version of that, and I think that's fine, and I don't see an issue with that. If that's the way it is, without potentially stepping down.
Yeah, and by the way, that's Pam that does all that work, so let her know. Okay, just so people, you know, I think we should look for agreement, and we can come back and say, yes, we are willing to participate in this activity, and here's what we're doing, and then we can draw boundaries. Jeff?
Yeah, so having served on committees appointed by the select board and committees appointed by the planning commission, neither has ever had charters until the recent underwear we put on. There's something about, you know, how we're adjusting things that has facilitated this charter paradigm. I don't necessarily have a problem with the charter. So, you know, as chair of the corridor committee for a lot of years, the bandstand committee, Lucy Gibson on the transportation committee for the select board, which then got abolished, and the planning commission picked it up and then let it expire again, and now the affordable housing subcommittee. None of these committees, and myriad subcommittees over time, have had charters. That said, in this new construct, okay, I don't have a problem with the planning commission saying, to the extent we want to appoint members, here's what we want you to do.
Right.
The extent we do charters, I think it should be broad and to the extent the planning commission is fine with that. And the flip side of that is, I don't really care what the select board thinks, because, you know, we need to serve the law, the VSAs. And select board has a legacy of violating the law, and they can kick us out if that's the case, or they can join us in supporting the law going forward.
Mm-hmm.
And
Yeah, I
see
mean,
Chris-
and I know, okay, go ahead, Chris.
Yeah, the only thing, I'm not sure where the word charter, I know, Jan, that you kind
Yeah.
of
Yeah.
added that, but can I tell you that over the years that I have been watching the select board violate the open meeting law, as Jeff said, that the one thing I will agree on is that they never use the word charter. They have always used the word, what is your charge? So the finance committee was always, what is your charge? And your charge was such and such and such and such. And it usually typically was broad. They're, you know, they typically think of committees formed by the select board in the past. I don't know so much about the planning commission, but it was just, what was your charge? Which is another verbiage of way, what are you guys gonna do? Because we don't
Right.
really need a committee unless you're doing something, right?
Right,
So
exactly.
the word charter seems to sort of have I don't know, it just seems to elevate it to proportions that maybe.
Well, too highfalutin. Yeah.
Yeah.
And I agree. I mean, I think the point is, and we should stay local, you know, talk about examples that we've had, right? So we had, I think the solar siting subcommittee is doing well because we kind of know what we're doing. It came with a pretty narrow purpose, charge, whatever word you want to use. The land use subcommittee was a little too broad, and it was harder to know what was to be done, and it floundered accordingly. And we're trying to get the multimodal to and it sounds like, and that's why I want to hear the report, it sounds like, you know, you have come up with a purpose, so to speak. So I certainly don't care about the word that's used. I do think it makes sense. Jeff's argument about 5 people is perfectly sensible to me. I think it's sort of just obvious best practice to say, if you're gonna bother to get together, that you have a purpose for doing it, and that it's generally commonly shared what the purpose is.
What are we doing here?
What the heck are we here for? So that's kind of where I would put it. What do people feel? So let's take the 5 members for a minute. Or Bob, did you have something?
I guess I would say whether or not there's been, I mean, it doesn't have to be a formal charge or charter or whatever. I would say, as a person who moved here about 3 years ago, you know, within some of the groups in town and whatever, to frequently hear, oh, that's how we do it, or everybody just knows. Maybe everyone's interpretation on how we do things or what everyone knows might be a little different. We're not trying to write any legal document or clear statement of what must be done. So just a little guiding charter, charge, whatever the verbiage is, some idea of, like, you know, what like expected practices are, and as informal as possible. It's not going to hurt anything. It might even help. I mean, there's plenty of people in town that might want to get involved in things, to have a clear idea of just what it is that's going on within the groups. I mean, I'm assuming we're not going to spend weeks debating it. It probably is just something that someone will come up with, and hey, is everybody on board with this? And that's that. So, I mean, I think there's some benefits to it, even if it does sound a little ridiculous or maybe different from how it was done before. Anything that gets more people involved and helps out, helps forward progress.
Yeah, I think informal is a good word, and in a way that builds participation or points people in the right place. Like when it was, oh, we got to do a Route 5 bike survey. And if you know what these groups do, then you know to give it to multimodal rather than to solar sighting because they have a purpose. Jeff?
Yeah, I mean, I appreciate what Bob said. So my view of the membership is at least 5 members. And like the transportation committee of the select board might have had up to 9 or more. And the affordable housing subcommittees had probably 7 or more different times, but at least 5 members. The transportation committee of the select board was basically charged with looking at vehicles, bikes, and pedestrians. So something very generic. I'm not sure it was ever written down in that context, but if it's that simple, fantastic.
Yep. Bob, just a second, Chris. Bob, did you have your hand up before?
Oh, no, I mean, just to kind of echo what Joe was
Okay.
saying, I'm not picturing a HR handbook that you get, given to you on the first day at work where you've got, 37 pages or whatever. I'd say 2 sentences.
Yeah.
Something like that.
We'll see.
I'm not trying to build it up too much, but
No, I think that word informal is helpful. It's, you should know what people are doing, but you can be pretty informal about it. Chris?
To quickly to Bob's point, I think it's just really letting the public know. And this all went back to the select board making up these committees and not following the OML. And everybody was wondering, well, what are these committees doing? So it's really not just for the committee to know what their charge is, it's for the public to know what it is they're doing. So anyway, going back to Jeff's idea about whether it be 3 or 5, I'm a little confused because we had a problem in our little group, in our solar siting committee. We wanted to incorporate as many people into the committee, and and we had members of the community who said they didn't want us to. So I'm not quite sure how we are going to address that, but we were also, I think the solar siting committee had maybe, more politically charged or energy charged concerns. So maybe the multimodal hasn't created that same kind of thing. So I'm not quite sure.
Create it. It came with our charge.
It came after us. So I guess I'm not quite sure if are we creating. I'm still not sure what difference does it make when we create these committees or somebody creates a committee. Do we really, are we trying to determine that we should have 3 or should have 5? I'm not quite sure what the point of this.
Yeah, and so actually, Chris, it's a very good point because that's what I said to Jeff, and I said it to the select board. I used the solar siting committee as an example, and I said we have 3 members of the planning commission on there who are chartered to understand the OML and make sure it's followed. And then we don't have any other formal members because we want people to come and participate. Now, after I talked about it with Jeff, I think there is an advantage, and whether it's 3 or 1 doesn't matter much. If it's not 5, then your quorum, the whole 2 people can talk without being a quorum. You got to have 5. But so I was convinced talking to Jeff that the 5 seemed to be a good idea. And then I would just open it up with that to say, okay, who are the members? Like, who can we pick? Clearly we're saying the planning commission is picking the members of its subcommittees. I hope we're not arguing that point much. But how many, is there some minimum number that have to be planning commission members? What's the pool you can draw from in picking them? Jeff?
Yeah, so I think we should say strive for a minimum of 5 members. It doesn't mean you can't proceed with 3 members. I think the only folks we might exclude would be select board members. I'm sinning again, Lord forgive me. Anyway, it doesn't matter where the folks come from. The Affordable Housing Subcommittee right now consists of 1 planning commission member. That's me. The Affordable Housing Subcommittee had a member from the town of Hartford. That was Ralph Ivins at the time. So it's not material to me, at least, how many members of the planning commission are involved. What is material is whatever subcommittee convenes needs to adhere to the open meeting law.
Yep.
I'm not going to come back to the ironies of what Chris has mentioned and how here we are striving to do the right thing according to the law, and we're being undermined. That's my polite way of saying second. Anyway, so to me, like I look, Peter Warner, I'm drawing a blank.
Paul Magnello was also the,
Paul Manganello. Yeah, so we had to recruit those two immediately to,
Yeah.
And then if there's a third member, fine. So, you know, if the planning commission thinks there ought to be one planning commission member on the subcommittee, that probably makes some sense just for procedural purposes. Other than that, I don't care.
yeah. Yeah, I mean, I think if I would say one is the bare minimum, just, I mean, somebody's got to report back to these meetings. You want it to be a planning commission I mean, we're talking planning commission subcommittees. We're not talking an ad hoc committee that popped up out of somewhere, you know, where for the conversation of a planning commission subcommittee, I would say part of that is there's got to be at least one planning commission member. Yeah.
No, I want to argue though, the transportation committee never had a select board member. The corridor committee never had a select board member. Both were appointed by the select board. So
Yeah.
the premise, the member of the appointing committee has to be present, I think is fallacious. I'm just talking administratively for us to ensure
Yeah.
open meeting law conformity. It
Yeah.
might make
Yeah. Chris?
So I'm not really talking about numbers and this is not something I think you can write down. You can't codify or something like this. But going back to our solar siting, when we were trying to form it, what I personally would like to see, we tried to open that up and try to get members, and then we were really kind of shut down. And quite frankly, I believe that in any committee of any kind, select board, planning commission, it should be a well-rounded. It shouldn't be gathering of everybody who is like-minded. And I think that we should all be challenged in all our committee meetings. And I think we should shouldn't always think that we should have people who are in agreement on everything. So I think that was my one really big disappointment when we had people who said, you know, anybody who was involved in Upper Loveland can't be on our committee. I found that I was really disappointed to hear people say that they had that they didn't, their opinion didn't count because they have whatever. And I'm thinking, no, we should be listening to every single person's opinion and not stacking these committees.
Yeah. Let's start Jeff and then Rob.
Yeah, so I think the energy, the solar siting committee is not a fair topic in this context. I think with respect to folks like Jay or Mary, they were in the midst of a legal battle, among other things, if I understand it correctly. And for the record, if the planning commission said we're not going to pick anybody that lives in the Upper Loveland realm, I wasn't a part of that. So going forward, I would be hopeful that folks like Mary and Jay would join the solar siting committee because they seem to know what they're, you know, what's afoot, if you will. So I think the contention with respect to that particular subcommittee is an outlier.
I disagree. The land use committee had the same kind of problems. And I know Stuart expressed that, and Ernie, I don't know about Bob, but it was the same kind of thing where, people are trying to get out there, and I've seen it happen on the select board, where certain committees, they only, are selecting people who are like-minded. And the one thing I would say, if we're trying to encourage, I don't know if we're trying to encourage numbers, I would say that we should be encouraging, a well-rounded group of people who want to have a conversation.
In the back and forth here, and I know Rob's got his hand up. Look, this planning commission in its current constitution is evolving.
Yeah.
I'm not saying I agree or disagree, but we try to put together various subcommittees. Going forward, I think Chris's principle, which is let's invite folks to participate, I completely agree with.
Yeah.
I would have loved 10 people in the solar siting committee of all different opinions.
Yeah.
So
Yeah, well, so I think we should, let's continue this conversation and we can, the point is, to Jeff's point, and then I'll let Rob speak and then we can move on. But the point is, we are evolving and we're learning things from the committee so that when we start talking, what's the solar siting committee doing? What's the, because I have a particular point on the multimodal, which I really am interested in, how to get participation and how to really use that. So let's just keep this in mind and keep evolving it. Rob?
I was just concerned because the description of the meetings that Chris just put forward are not the meetings I remember that attending. There was concern. I remember there was concern about encouraging specific people to be a member of the committee, not a broad invitation. And the objections were that it seemed as if there was a movement towards inviting specific types of people with stances already known. So I take a little bit of exception to the referral over and over again that that the people involved did not want a broad, diverse committee, but rather that we were concerned that there might not be a broad, diverse committee. Thank you.
Mm-hmm. Thank you, Rob. Okay, let's take this as an open topic that we want to continue to talk about, and now we can talk a little bit on the two committees and use that as fodder. Chris, if I may, on the solar siting, just because we're short for time, and I wanted to put this, and as I wrote in my note to you and Ernie about potential agenda, we had the decision that was made in that committee to take on the project of doing an enhanced energy plan and updating our plan so that it met that criteria. And then we were going to have, a week from tonight, we were contemplating having a kickoff public participation. I'll write a listserv post, tell people why you should care about your enhanced energy plan, and please come and so forth. But I also was talking to Pete Gregory and Kyle and others on looking for a resource to help us with that and to answer questions. What does it mean to go through this process? And the message I got from those queries was Norwich is pretty close. Norwich's plan could be an enhanced energy, and these are the regional commission people that have to approve it, and they're saying, yeah, you change a few lines, and actually the Vermont data is being updated, so the energy appendix data would be updated. But it was a pretty, as Pete Gregory said, it was no big lift to get us. So I wasn't going to make a big hoopla in a listserv post in a public kickoff if it was 15 lines in a town plan and referencing new data. So that's kind of one picture about the effort. But the key one, which is the one we were talking about tonight with the preferred solar siting, essentially the entire conversation, the only contentious issue in touching the town plan energy component is the proposal to remove the default solar. And so I just want us to be clear that it's not as if we're doing this great big enhanced energy plan project that has as one small component looking at where preferred sites are, that's really 80–90% of the topic. And so we should just be conscious of that and say, all right, how does the group feel about that, both the subcommittee and the full commission? And if we choose to open up the topic of taking default preferred away, then how do we go about that? Jeff?
Yes, since this is going to be a future agenda item, I appreciate you cracking the door open here. So in addition to what you said for a future agenda item, relative to the preferred siting concern, what has been legitimately expressed, I think, by folks is stuff like, what are the natural resource conditions? And so tonight, hypothetically, I heard someone in the audience say, you know, I live there are no vernal pools. And in my world, there are licenses and things that really matter. So if it matters that applicants or people who are requesting these things actually have legitimate, accurate site analyses, that might be something we want to consider going forward. Because I think Upper Loveland did not have that stuff at the outset.
Okay. Chris?
I'm not quite sure how we're gonna, I'm not sure what agenda item we're on, so I'm not quite sure where to go with this.
Well, we're on solar
Yeah.
siting, and I think we're trying to ask,
Yeah, I
we're
know.
trying to ask the larger group to help us frame
Yeah.
the activity, and that's really where I was coming from.
So no, I think it's great because I because OML didn't want to respond to you. But I totally got what Kyle, or I think, was it Kyle or Peter that was making that suggestion that it's really not, Norwich is already, you know, 9/10.
Yeah, both of them agreed. Peter said Kyle's your resource, and
So-
Kyle said it's easy.
Yeah, I think the only thing is that I'm really glad that both Mary and Jay spoke and expressed, I think, concerns that are more people have concerns with, that the process and what does this ridgeline protection actually mean? And I'm not quite sure if, again, while the T-Rock doesn't really see that, you know, well, of course, Norwich has already jumped on the energy bandwagon, but there's some people who actually have concerns. And those two expressed it. So I guess what I'm trying to say is that in the solar siting committee has been talking about, and again, I hate bringing this up. It's not just 248 review, but 248 review now requires, if you want the substantial deference, is you have to pass the Queechy test. Now, in order to pass the Queechy test, we just would simply, if where Aaron Lamperti's land is, if that had been designated, that hill, we wouldn't have been having this conversation tonight. So the Queechy test is remarkably a very straightforward document, or, you know, it's very straightforward set of principles that the PUC is trying to tell us. If we're trying to protect anything, you can't just say the town of Norwich has ridgeline protection based on a couple roads that you may or may not be able to see from it. They're actually saying you got to name. It's exactly what Jay Benson was saying, and Mary Gorham. If you want to protect Jay Van Armen's land, it's got to say you can't develop on Jay Van Armen's land. They are actually saying you've got to be specific. You got to be specific about your roads, the ridge lines, and you got to start naming things. So I don't know how we express the enhanced energy plan as part of that process. And I think it will, that we have to start naming names on our the areas we want to protect very specifically. So it's not just getting rid of the, we can't just like sort of say, well, let's get rid of the preferred site. We got to start naming.
No, you can't. And that's really the question. And I agree with Jeff. It needs to be an agenda item either on the subcommittee or the whole.
Yeah, that's what I'm sorry. That's what I'm trying to say.
But
I wasn't trying to
the
get into that as much as it was how we're going to approach it.
But I think you're right. The point is that if you take off the default, then you have to put something in its place, or you will not be an approved enhanced energy plan. And
I'm saying something different. What I'm saying is, Queechy test aside, what are the natural resources that we're concerned about that may be involved in our review of an enhanced energy program? And let's put that on the agenda.
yeah,
Oh, isn't that what I
Okay.
just said though? Isn't that the part of what we were saying, the natural resources?
I thought I said it before you said it, and then you said it. You said it.
all right. So I think Chris, we can talk separately around what's the agenda for the next solar siting subcommittee. That's OML acceptable to talk agendas. So let's take that. Multimodal and like I said, I want some time for minutes at the end, so no fair throwing in a motion to adjourn in 30 seconds or anything, Jeff. But on the multimodal, I definitely want a report and a feeling back, because it sounded like you had said from the minutes you want to kick off a master planning activity around, and this is my question, how does that relate to is it sidewalks, trails, pedestrian, bikes all together? Is it specific to sidewalks?
Buses, airplanes, trains. What was it when you carted up this, anyway, everything. So
Okay.
I'm
So
gonna
how,
defer, Jan. So Vince and I'll meet, we'll come back to you, and or we'll do a public thing and we'll come back. So we're almost out of time, so we'll get back to you next time.
well, so can I just ask you in that conversation, my hope in the painful conversation that was the sidewalk conversation around surplus money and so forth. There are a lot of topics around sidewalks. Everything from the fire district owns some of them and the town owns some of them, and they need maintenance, but there's some new ones that would be really easy to build, and everybody was sort of getting all tied up in knots by very specific short-term ideas and then longer-term planning topics. And it really gets to the bigger picture, which I want to put on, I want to emphasize when it says planning commission charge, so to speak. Capital planning is clearly, there were several good, Katuki had a great post saying Norwich should do capital planning. How the heck do you capital budgeting without a capital plan first? And so
it's in the law for us.
Yeah, it's number 6 in the statutory things of here's what a planning commission does. And so I want us to really raise our hands and say, we want to participate in that. And so as a subset of that, I think the sidewalk question is a decent example that says, ain't nobody else doing it. The select board is hemming and hawing and kind of pointing one way or the other. But if we could step in and say, part of this master plan is a sidewalk inventory and mapping and so forth, and a capital plan for that resource, then we would be doing what we're supposed to be doing for something that's clearly, this festering topic that never goes anywhere.
Jan, I see it the same way you do, but I would add every mode of transportation to that, with the notion that we might approach sustainability. So I don't care whether it's the airport, I don't care whether it's AT, I don't care what it is. Everything you said in the context of CIP, in the context of sustainability going forward.
Okay, I totally agree. I would just be wary of such a big topic that we couldn't bound it enough to make progress on any one part. But if we take on that challenge, then we just need to address that.
Jan, I thought that when we were sort of reviewing the enhanced energy plan, that the exercise itself included capital planning. So that's why I kind of like the
It
idea.
can have an element. I think part of what we were talking about, like what Kyle's talking about to make it sound easy, is what you have to, the minimum you have to get an EEP. But you can go over and above that and say, okay, we're going to do capital planning of, what you're doing with Tracy Hall or infrastructure, or you want to support more bikes or all that stuff. So I think we could take on as much of that as we wanted.
Yeah, that's what I mean, again, this is part, we'll get into this. It's not really this agenda. We'll get to it on Tuesday, but I was kind of looking forward to the enhanced energy plan. We were only going to sort of say, yes, we want to do it. Then I thought we were going to come back to the whole planning commission and actually incorporate that the enhanced energy plan was kind of going to do all that. As sort of a catalyst to incorporating the larger picture. But now it sounds like they're just sort of going to brush it off and just say, sign off on it. And suddenly the town's, enhanced energy plan.
Well, and I think that's where we need to define what we want to touch and change and work on. And we don't just go for the threshold. The threshold is useful because you get substantial deference and that's useful. But it doesn't mean that we need to stop there or somehow only do what's necessary.
Can we do minutes?
Yeah, let's do minutes.
2 minutes.
Yeah, let's do minutes.
That's looking nervous.
So we've got December 12th. I had just one town clerk with an A, second line from the bottom, first page.
To approve.
You want, okay, move to approve and then we'll
Is there a
discuss.
second? Bob
Bob second, okay.
Discussion.
And then the only other one I had under 6, in a minute, Jeff, was the solar subcommittee definitely didn't say we would present to the next PC meeting an advanced energy plan.
Okay,
So I think.
How about I strike that?
Yeah, I mean, solar siting subcommittee said that we were proposing to take on the task of developing an enhanced energy plan. It will be a several-month project and we will report regularly to the planning commission.
Okay, I can have that.
Okay, that's all I had. Jeff, on the 12th?
No, I was just trying to get us to make a motion, second.
All right. Any other comments on the December 12th minutes? All right, call the question. All those in favor?
Aye.
All right, unanimous. I did not have anything to change on the 9th. Did anybody else have changes?
Approve the minutes of the 9th.
I'll second.
All right, any edits, changes, comments? All right, all those in favor, approve the minutes of the 9th. Thank you, unanimous. 23rd, which is the special meeting we had, an executive session. Cheryl commented, and I think usefully, that we were missing some key points. Executive session, you have to say exactly what time you went into executive session. Motion to approve the minutes of
Okay, now.
123. Thank
Go
you.
ahead.
Second. So I would add to motion passed 5-0 to enter executive session at 6:40. And then motion to enter public session passed unanimously at 8:04. And then we didn't have the vote on that motion. After executive session moved and seconded, it needs a sentence at the end, voted for Crow, Goodrich, Losbrough, Pape, Clement, unanimous. So it has to say that it was 5-0 and who voted what.
Oh, I see. Right before adjourn. Okay.
Right before the word adjourn, it needs to say who voted for.
Okay.
And then just put the time we adjourned at 8:10.
And it was 5-0 and everyone, but write everyone's name out.
Yes. Any other comments on those minutes? All right, thank you. All those in favor of approving those minutes? All right. Aye. I will entertain a motion to adjourn. If there's no public, we got no public that can comment. Amy won't comment, I promise. And so I will take a motion to adjourn.
So moved.
Second. Thank you all.
See ya.
Got some work done. Chris, we can talk about solar.
Yeah,
Good.
no, that's fine. I agree
All
with
right.
it. I agree with
All
what you
right.
said.
All right, thank you all. Good night, everyone.
Night.